We have an action-packed lecture ready for you today. I know sometimes we cover one chapter, sometimes we cover two chapters. Let's cover 3 chapters, shall we? Okay, since everyone's in agreement. Today's lecture topics include separation of powers, sovereign immunity, delegation of powers. Separation of powers is a constitutional right under Florida's Constitution. It's implied within the Constitution of the United States. Certainly, case law precedent interpreting that implication is binding. But here in Florida, in our Constitution, the text of the Constitution says so. And indeed, you have a constitutional right here in Florida to a separation of powers. So we'll be covering separation of powers today. We'll be covering 2 related topics. Obviously, delegation of powers is related to separation of powers. If powers must be separated, can they be delegated? We will answer that question for you today. And in between those 2 topics, we will cover a topic that I suggest is also related, the topic of sovereign immunity. Sovereign immunity, that archaic notion that survives today that says that the state is immune, the government is immune from lawsuits. Should it be? Is it always? When is it immune? When is it not? We will cover these topics and more. But before we do, I thank you once again. You've always been kind enough to allow me to start every class with a prayer, and I will do so yet again. As always, I'm not praying at you, I'm praying for you, and I'm praying for your success. Maybe my prayers for your success in the midterm were granted because I think this group got a great group of scores on the midterm. Even the lowest score in the midterm still statistically leaves that person eligible to book the class. So everyone is still in the hunt. And of course, I hope the grades have been released, have they not? Yes, and I hope you were as pleased with them as I was. So thank you for working so hard in this class. My prayer for you, as always, is that you succeed on these little quizzes and exams that you get from little old meaningless people like me, but more importantly, that you succeed in the bigger tests of life, and that success always comes your way. And I make that prayer for you in the name of the Father, and of the Son, and of the Holy Spirit. Amen. Our Father, who art in heaven, hallowed be thy name. Thy kingdom come, thy will be done, on earth as it is in heaven. Give us this day our daily bread, and forgive us our trespasses, as we forgive those who trespass against us. And lead us not into temptation, but deliver us from evil. Amen. Hail Mary, full of grace, the Lord is with thee. Blessed art thou among women, and blessed is the fruit of thy womb, Jesus. Holy Mary, Mother of God, pray for us sinners, now and at the hour of our death. Amen. In the name of the Father, the Son, the Holy Spirit. Amen. Separation of powers is indeed a constitutional right under Florida's Constitution, and that's because you can see it there in the text in Article 2, Section 3. In which article, in which section do I find such an explicit grant of a constitutional right in the Constitution of the United States? I hear silence, and that's the correct answer. Yeah, it's not there. It's not there. But it is in the text of the Constitution of the state of Florida, and I have it for you here on the big board. As you can see, Article 2, Section 3 reads as follows: the powers of the state government shall be divided into legislative, executive, and judicial branches. No person belonging to one branch shall exercise any powers appertaining to either of the other branches unless expressly provided herein. Therein lies the rub, huh? Unless expressly provided herein. Part of our syllabus is to read the entirety of Florida's Constitution, so you have read and you have noted that on occasion there is quasi-legislative powers granted to the executive and judicial branches. There are quasi-executive powers granted to the legislative and judicial branches. There are quasi-judicial powers granted to the executive and legislative branches. So there is and there can be some overlap. But to begin at the beginning, there is the requirement, unless the Constitution states otherwise, that there must be a separation of powers. And our textbook started with some good quotes. I've got a few of them here on the board. The one on the left comes from the Federalist, specifically James Madison. It's quoting from the Federalist number 51 at 322. It reads, and you read it already, as follows. In framing a government, which is to be administered by men over men, the great difficulty lies in this. You must first enable the government to control the governed, and in the next place, oblige it to control itself. And that's the part I'll highlight in green for the moment. To oblige it to control itself. As we look at the separation of powers, ask yourself, to what extent does this requirement of a separation of powers, this constitutional right to a separation of powers, help to oblige the government to control itself? Because what happens when a government does not control itself? Or, for example, what happens when your slide presentation takes control over itself? What is this box? It's a cloud. It's Windows. Anybody here use Windows? A few years ago, I decided to remove Windows from my life, which is almost impossible to do. But about 99.5% of my life is Windows free. They give me this computer here. It runs on Windows. I've got to use it. So this is the 0.5% of my life that has Windows. I tell you, the rest of my life is such a better place. Yeah. So my advice to you, whether you're running a law firm, trying to give a lecture, or just trying to send an email, if you can get Windows out of the picture, it'll work better. Let me see what I can do about this Windows thing here. Yeah. All right. Okay. I noticed with Windows, it's always in charge. For example, that was just telling me that it's time for me to install something. I don't know. I thought it was time for me to give this lecture. But Windows says it's time for me to install something. Sorry, Windows. That's not true. Okay. So back to my Chromebook over here. Love those things. iPhone, Android phone, love those things. Fire tablet from Amazon, love that thing. But Windows, if you got Windows, yeah. Anyway, I digress. So what I'm talking about here is obliging a government to control itself. And that's what the Federalist number 51 from James Madison is talking about. What do you have if you lack a government obliged to control itself? If the government does not control itself, then what do you have? That brings us to the next quote on this slide. This one is from our textbook also. It is quoting from Daniel Webster and others who wrote a Nova Law Review article called First Principles from 1997. And I quote from there, quote, tyranny arises most easily when all power is concentrated in the hands of a single person or in the hands of just a few. A constitution that divides power will best protect against tyranny. So I highlight for you there this part of the quote. Tyranny arises most easily when all power is concentrated. When it's concentrated. When there's a lack of separation of powers. And instead there's a concentration of powers. One problem that may arise, some might say will arise, is the problem of tyranny. Tyranny. I ask you this. What's the opposite of tyranny? Or stated somewhat differently, what concept that we previously discussed could be called the antithesis of tyranny? I'm hearing it. The hands up. Go ahead. Yes, thank you very much. Who knew I would bring up that topic? Huh? Who knew? And of course, that topic will be the topic of your graded essay, which in Friday afternoon, I will make available to you on our class website, flaconstitution.com. That's when you can start to take a look at that. And as our syllabus says, it will be due to me in our last class. But that's housekeeping stuff. I try to avoid wasting lecture time on housekeeping stuff. I mention it not for the purpose of housekeeping, but to pique your interest in yet again discussing subsidiarity. Let's do it, shall we? You remember what subsidiarity is? This was a concept from Catholic social justice teaching, which has been adopted Worldwide, you can find it in the text of documents such as the Constitution of the European Union. You can see governments have been structured, constitutions have been written, policies have been made based upon the concept of subsidiarity. Subsidiarity, what is it? I like to quote from St. Pope John Paul II in his 1991 encyclical, Centesimus Annus, where he defined subsidiarity in this way, and it's up on the big board. You've seen this slide before. Subsidiarity means, according to St. Pope John Paul II, a community of a higher order should not interfere with the internal life of a community of a lower order, depriving the latter of its functions, but rather should support it and help to coordinate its activity with the activities of the rest of society, always with a view to the common good, always with a view to the common good. So I've highlighted and underlined on the slide a couple of concepts. The first, one of interference. If a community of a higher order interferes with the internal life of a community of a lower order to such an extent that the lower order's authority is meaningless, what do we have? I would suggest we have tyranny, correct? Instead, I've underlined support it and help to coordinate its activity with the activities of the rest of society. Support it and help to coordinate it. This is a better description of a separation of powers, where each of the three branches, in order to form an entire government which provides all functions, must support to a certain extent and certainly coordinate with one another. And in so doing, the separation of powers advances the concept of subsidiarity and threatens the concept of tyranny. The third part I highlighted in the definition from Pope John Paul II is the common good. We don't support and help coordinate the internal life of the community of the lower order simply out of the theory that it has a right to exist. No, we support it for the greater good, for the common good, for the good of mankind and humankind as a whole. Subsidiarity rejects the notion that all problem-solving power should be vested only with the highest sovereign or federal authority. To vest all power and to concentrate it in that way would be tyranny. Subsidiarity rejects tyranny. Subsidiarity respects the proper role in problem solving by each of the three separate branches of government, be it legislative, be it executive, or be it judicial. Each has its role to play, and subsidiarity allows for overlapping powers. McGinley, how do you come to that last conclusion? How can you say that subsidiarity allows for overlapping powers? Well, if we look back at the definition, which apparently Windows is not going to allow us to do. I'm sorry, Windows. I'm not installing this thing I don't need right now. Okay, there you go. I shouldn't talk to the boss like that. Windows is the boss, right? Windows runs our lives. If Windows says I'm done, then I guess I'm done. Sorry, Windows. Okay. If we look back, tyranny arises most easily when all power is concentrated in the hands of a single person or in the hands of just a few. Subsidiarity, on the other hand, urges that the community of higher order doesn't interfere with the communities of lower order, but instead supports them and coordinates their activity with the activities of the rest of society, all with one goal in mind, the common good. For that reason, I suggest it's a fair conclusion, the conclusion you see last on my big slide, that subsidiarity allows for overlapping powers. Perhaps there is a time where the higher order must interfere and intervene for the common good. I suggest that a proper definition of subsidiarity does not rule out such a scenario when such a scenario helps the common good, and leaves the community of a lower order intact. How can we interfere with the community of a lower order but yet leave that community intact? We can interfere in ways such as support, ways such as coordination with the rest of society, ways that help the common good. So subsidiarity certainly rules out tyranny. But I would suggest that subsidiarity does not rule out overlapping powers. We studied earlier in the semester Florida's state government, Florida's county governments, and Florida's city and municipal governments. We noted that they often had overlapping powers. And I suggest, based on St. Pope John Paul II's definition of subsidiarity, that overlap between state and municipal government powers does not interfere or rule out or thwart subsidiarity. That's my theory. Perhaps your theory may be different. I look forward to reading your graded essays. Now, turning to dissension among the branches, sometimes the branches don't get along. That was certainly the case in the case of Florida House of Representatives versus Crist, which it's hard to tell because it's 4, 6, it's still 11 pages long in my text, but believe it or not, I did edit it. I've done a better job of editing cases, granted. You've seen some of my texts that are just a page or page and a half. I left a lot in here because there's a lot to learn from this case. Not the least of which is gambling. Anybody here like to gamble? Okay, there's irresponsible gambling, right? There's addictive gambling. We've got to avoid addictions, right? But if we can avoid addiction and we can gamble responsibly, we're not using money that the family needs. We're not using money that we need for our basic human needs. If we're using some of the money we would have spent on a movie theater ticket or some other frivolous price, and we gamble it within moderation, then we're okay. At least I hope so, because that's what I do. I love a little blackjack now and then. Everybody play blackjack? Yeah, right? All you got to do is be able to count to 21. I can handle that. Yeah. Or even less skill, craps. Anybody play the game of craps? Just some rolling dice. Yes. Great game, isn't it? Hey, I'll see you after class. All right. But I like craps because in the blackjack, you can fool yourself into thinking that you might be exerting some control over the outcome of the game. You cannot fool yourself in a game of craps. The dice roll is the dice roll. There's nothing any of us can do about it, right? So there are different ways of gaming, and that is the topic of this case, Florida House of Representatives versus Crist. At issue in this case was November 2007 compact between the Seminole Indian tribe of Florida and Florida's governor, who at that time was Charlie Crist. What is a compact? Compact is a type of contract where the parties to the contracts are both sovereigns. Sovereigns, meaning what? Meaning nations, meaning states, meaning lawmaking authorities. And that's exactly what we've got here. We've got the sovereign of the state of Florida, and we've got a separate sovereign, the Seminole Indian tribe of Florida. They got here before we did. They were sovereign long before we were, and they remain sovereigns today. So the contract there is correctly labeled in this case as a compact because it is a contract between two sovereigns. What did this particular compact do? It significantly expanded casino gambling, also known as gaming. In Nevada, you call it gaming. You know, in Florida, we can call it gambling, but it's gaming out there. I don't want to offend anybody from that great state. So whether you call it gambling or gaming, it was greatly expanded under this compact. Statewide? No. On the land of the Seminole Indian tribe of Florida and other adjacent lands or lands controlled by the Seminole Indian tribe of Florida, according to this November 2007 compact. Now, was it true that the state of Florida allowed all this type of gambling or gaming? The answer was no. Not only was it impermissible, it was a crime under the Florida statutes. But it would have been not a crime and would have been permissible under the November 2007 compact between the Seminole Indian Tribe of Florida and Florida's Governor Crist. How could such a compact arise? Please, Windows, please. How could such a compact arise? Well, under federal law, specifically at that time, it was 25 U.S.C. sections 2701 through 2721, also known as the Indian Gaming Regulatory Act. I didn't make up that name. That's what's in the statute. Don't blame me. We'll call it the IGRA. So under the IGRA, a state sometimes had the right and sometimes had the duty to negotiate with sovereign tribes such as the Seminoles to make such a compact. Now, as we know from the facts of this case, the tribe, in good faith, had attempted to negotiate such a compact under the IGRA for many years, but it just never got done. So, Florida's governor, at the time Governor Crist, felt empowered by Florida's Constitution, specifically where it says that he has the authority to act as the chief executive of our state. He stepped in and made what he felt was a good deal for both the tribe and for the state of Florida. In this lawsuit, we see the Florida House of Representatives, obviously the legislative branch, filing a lawsuit. Where do you file that? Obviously in the judicial branch, against Florida's governor, obviously the executive branch. So here we have the battle of the titans. We've got one branch of Florida's government, the judicial, presiding over a lawsuit between another branch, the legislative, and the third branch, the executive. If ever any case is going to clear up some of our separation of powers issues, this is going to be the one, right? Which is why I've got so much of it in your text. Even though I swear, I edited it down. I swear, it's hard to tell, but I swear I did. So what happens here? The negotiations between the tribe and the state result in the compact. The compact recites that the governor, quote, has the authority to act for the state with respect to the negotiation and execution of this compact, end quote. So both the governor and the tribe were wise enough to include that language in the compact. The compact will grant the tribe the exclusive right to conduct certain types of gaming. It can do some of what the IGRA refers to as Class 3 gaming. Class 3 gaming consists of banked card games. Class 3 gaming is prohibited, not allowed, made illegal, and made a crime under the Florida statutes. Class 3 gaming, as I mentioned, is banked gaming. What is that? Well, for those of you who aren't gamblers or gamers, you can gamble in such a way that it is a pari-mutuel. For example, we used to be able to bet on greyhounds, and you would bet win, place, or show, and the house would collect all the bets, would take its vig or vigorish, meaning its percentage of those bets, and would distribute the rest of the bets to the winners. So in that kind of pari-mutuel gambling, which would be not Class 3 gambling, the house can never lose, right? And the winners can never get more than the pot, by which I mean the sum total of all the bets placed by the bettors at that time. Class 3 gaming or gambling is different in that it is banked by the house. The winners can win more than the sum total of the pot, can win more than the sum total of all the bets placed on that particular hand or round or game or action. For that reason, the house can lose. Also for that reason, the house can win. Because unlike in a pari-mutuel scenario, the house need not keep only its vig or vigorish and return the rest of the bets to the winners. Indeed, there could be no winners. There could be a sum total of winnings that is far below the sum total of the pot. And the House keeps it. So that's what we're talking about under the IGRA when we talk about Class 3. And you'd get more details if this were a gaming class in a Nevada law school, which we're not in. Sorry about that. So now, that's illegal here in the state of Florida. The court then turns to the law that applies to this interbranch dispute. They first define a compact, which we've done, is essentially a contract between two sovereigns. And in so doing, the Supreme Court of Florida recognizes the sovereignty of our Native American brothers and sisters and their nations, such as, in this case, the Seminole Indian Tribe of Florida. Other courts have addressed similar issues under the IGRA, Florida notes, but it's not going to decide this case based on federal law. Instead, I'm on page 260 now if you're following along. The Supreme Court of the state of Florida holds that it is Florida's Constitution that yields the answer to this mammoth fight of a separation of powers between Florida's legislative branch and Florida's executive branch. They cite to prior case law with this quote. We have, quote, traditionally applied a strict separation of powers doctrine, end quote, which is relevant because they are viewing this compact by the governor as an intrusion upon the separation of powers here in the state of Florida. How would this be an intrusion upon the separation of powers? The court views one of the three branches of Florida's government as the branch that decides what is the public policy of the state of Florida. And thankfully, in my opinion and in the opinion of all of us who hope and pray for judicial restraint, thankfully, the judicial branch speaking through the Supreme Court of Florida does not pick itself as the branch that is in charge of deciding the public policy of the state of Florida. Who then did the Supreme Court of the state of Florida in Florida House of Representatives versus Crist tell us decides what is the public policy of the state of Florida? Which branch? The legislative branch, says Florida House of Representatives versus Crist. So here in this 2008 decision from the Supreme Court of Florida, we clearly hear from Florida's judicial branch words of deference, words of respect for the democratic process in holding that it is our elected officials who we send to the Florida House of Representatives and the Florida Senate to make up the Florida legislature that is the ultimate arbiter of what is the public policy of the state of Florida. Because, says the Supreme Court of Florida, the legislature of Florida tells us the public policy of Florida. When the legislature of Florida made Class 3 banked gaming illegal to the extent that it was a crime, Florida's legislature was clearly and unequivocally, according to the Supreme Court of Florida, stating that the public policy of Florida was against Type 3 gaming, against banked card games, against the type of gaming or gambling at issue in this November 2007 compact between Florida's Governor Charlie Crist and the Seminole Tribe of Florida. That is among the important takeaways of this case when it comes to our study of separation of powers. What's another takeaway? How did this epic battle come before Florida's Supreme Court? Why wasn't it filed, for example, in a county court in the state Florida system? Why wasn't it filed before a Florida Circuit Court? Why wasn't one of the district courts of appeal hearing this? The reason and the first takeaway that you see on the big board is that Florida Supreme Court, as we studied in our last lecture, has quo warranto jurisdiction, alleging a violation of separation of powers. The violation of separation of powers occurred at the highest level, at the governor's office. The governor, obviously, is an elected statewide Florida official under Florida's Constitution. That meant that under the Constitution of the state of Florida, as we studied it in our last class, the Florida Supreme Court had jurisdiction in the first instance to hear the petition for quo warranto House of Representatives against Florida's governor filed in the Supreme Court of Florida. So in this instance, the party met the requirements. They were allowed to start at the highest, or at least our state's highest level of court. That jurisdiction exists even after the act has occurred, according to Florida House of Representatives versus Crist. So that's a takeaway that harkens back to our last lecture, where you named that writ, and we discussed extraordinary writs. The second takeaway is that the necessary business clause of Florida's Constitution does not authorize Florida's governor to execute compacts that are contrary to the expressed public policy of the state, and does not authorize Florida's governor to create his own exceptions to state law. There's two hands up. I don't know which was first. Okay, yes.
So, since this power is vested in the legislature here, did they end up going back to the legislature and negotiating with them instead?
Oh, you're jumping to the end. Spoiler alert. Spoiler, cover your ears if you want to hear the end at the end. Yeah. What we'll find is that although they had the authority to grant the petition for quo warranto, as we mentioned in our last lecture, all the extraordinary writs, even if you prove entitlement, are only granted at the discretion of the court. As we mentioned in our last lecture, even if you prove your case in an extraordinary writ, there was just one exception, certain type of certiorari writ. With all the others, even if you prove your case, the court can still send you away empty-handed. And as you see, that was the ruling here. The court expressed its confidence that now that it had gone through this laborious decision, and I swear I edited this one. I know how long it is, but I swear I edited this one. After they'd gone through all this explanation, they remained confident that the governor would do the right thing. So they denied entry of the writ. There was no relief granted to Florida's House of Representatives. So to answer your question, therefore, yes, that is what they did. They sent it back. They respected subsidiarity. They exercised judicial restraint. Love it when I see it. Hate it when I don't. Love judicial restraint. They exercised judicial restraint, and they sent it back to answer your question. Your question.
So I know they've actually changed this now fairly recently.
Oh, the gaming part of this. Yeah, I don't present it as an accurate description of today's gaming laws here in Florida. Those are in flux, and I believe it's a new compact. You're right about that.
What I'm saying is now, are they saying that it is part of public policy, or it's not against?
I think if there's not litigation still pending, I believe there is litigation still pending. So I can't accurately answer your question until that comes out. But your question is asking about the gaming and the gambling, and I'm with you. I could talk about that all day, except for when I'm actually gambling or gaming. but that truly is a tangent. It's the background to this case. It gives us the playing field and the reason for which the legislative branch of Florida sued the executive branch of Florida in the judicial branch of Florida. But it's not the point of my lecture. So you're right. When it comes to Class 3 gaming and banked card games, the future is still uncertain. So don't interpret this summary of the 2008 case of Florida House of Representatives versus Crist to be representing the current state of Class 3 gaming or gambling in Florida in general. I present it for the separation of powers issues. So you're right about that. You're right. Yes?
I don't know the details, but I heard the update that the latest legal challenge to the compact.
Yeah. Oh, so that's been dismissed or denied, or what happened?
I don't know if the official was finally dismissed.
Okay.
They lost the latest round.
So who's down for the count, or who's at least behind right now? Who's losing?
Those challenging.
Oh, okay. All right. So this compact might stick.
Yeah, looks like it'll go through.
Okay. Well, time will tell, and we'll see. But at least when we flash back to 2008 for the purposes of studying separation of powers, this compact didn't fly. Although the writ of quo warranto was not granted, the parties backed off. They considered it a nullity. To answer your question, they went back. They reworked it. Yes. Yes. Okay. So the second takeaway, how the necessary business clause, Florida's governor is empowered by the Constitution of the state of Florida. You read it. To conduct all necessary business. That's what makes Florida's governor our chief executive and the head of the executive branch. But necessary business doesn't mean you can execute a compact that's contrary to express public policy. Also, it does not mean that the governor can create exceptions to state law. And when we get to our notes and questions to consider, I'm going to bring that up again, because I'll inflame you by bringing up a controversial federal law, and I'll ask you whether or not that could happen under Florida's Constitution in the same way that it's happening under the U.S. Constitution. We'll get to that when we get to notes and questions to consider. But before we do that, I've got yet a third point that we don't want to miss from Florida House of Representatives versus Crist. Unless there is a tribal state compact allowing gambling, any gambling prohibited in Florida is also prohibited on tribal land that is within Florida. So yes, we do recognize in the holding of Florida House of Representatives versus Crist, the sovereignty of our Native American brothers and sisters, in particular, in this particular case, the Seminole tribe of Florida. Despite that recognition, any gambling prohibited in Florida is prohibited on tribal land unless there is a tribal state compact allowing for that type of gaming or gambling. A fourth takeaway, by authorizing the tribe to conduct banked card games that were illegal throughout Florida and therefore illegal for the tribe, this tribal state gaming compact violated state law. That was the holding of Florida House of Representatives versus Crist. Point 5 that you should not miss. The governor's execution of a compact authorizing types of gaming that were prohibited under state law was a violation of the separation of powers. So we talk about the theory about how powers should be separated. But what about the practice? What does it look like? What does a violation of separation of powers look like? The facts of this case are an example of what a violation of the separation of powers looks like. And point 6 that we don't want to miss, the 6th of our 6 takeaways. Florida's governor lacked authority to bind Florida to a compact that departed from our state's public policy by legalizing types of gaming that were illegal everywhere else in the state. Despite all these provisions throughout the Constitution that empower our governor to be the chief executive, still the governor lacked authority to bind Florida to a compact if what's done in that compact departs from public policy. And where do we look for public policy? Under Florida House of Representatives versus Crist, we find Florida's public policy in the Florida statutes elected by the representatives who you and I have appointed to go to the Florida legislature and debate and enact the laws of the state of Florida. That's the source of Florida public policy. So with all that in mind, we've got our notes and questions to consider. I won't do all those. I'm going to do number 1, 2, 7, and 8. We are on page 268. Note 1. Which branch of Florida's government does Florida House of Representatives versus Crist hold to be the branch that determines the public policy of the state of Florida? Legislative branch, correct. what impact could this have on Florida's other two branches? The impact it could have is one of deference and respect for the source of Florida public policy. In Florida House of Representatives versus Crist, you could argue that the governor's office lacked that respect and deference, but that the Florida Supreme Court acted upon and would have enforced that respect and deference. Note two, any extraordinary writ, like a writ of quo warranto, is a discretionary remedy, and so a party that proves its entitlement to such a writ may still be denied issuance of that writ by the court. Indeed, here in Florida House of Representatives versus Crist, Florida Supreme Court found that the House of Representatives was entitled to such a writ, yet the court withheld its issuance. In what way was this in deference to the separation of powers? I would argue that it's in deference whenever the judicial branch does not, by fiat, impose its will upon any other branch of government. I am not suggesting, and certainly under the case law, I cannot say, I've read Marbury versus Madison, that the judicial branch lacks the authority to impose its will by fiat upon either the legislative or the executive branches. It does. What I'm suggesting is going back to that quote from the Federalist Papers that I had on the big board from James Madison when we talked about a government obliged to control itself. Through the concept of judicial deference, we hope and we pray that courts will sparingly use their power to impose by fiat their will upon the other branches of government. Hopefully, we'll never see a day where it's the courts that decide whether the government goes to war or stays in peace, where it's the courts that decide whether the government does this or does that. Hopefully, there can be a separation of powers. And if there is to be a separation of powers, a true separation of powers, that in my humble opinion, there has to be judicial deference. There has to be. But that's my opinion. Opinions are like noses. Everybody has one. Maybe your opinion differs from mine. Note 7. Florida House of Representatives versus Crist holds that Florida Supreme Court has quo warranto jurisdiction alleging a violation of the separation of powers and has that jurisdiction even after the act has occurred. This holding defeated the governor's defense that the House could have acted sooner and failed to act in time. Is it necessary for one to wait and suffer the harm inflicted by a violation of the separation of powers before one may seek quo warranto relief? And a suggested answer to that question is the case I quote here, a 2017 decision where I quote from footnote 1 of that 2017 decision of the Florida Supreme Court called League of Women Voters versus Scott. There, Florida Supreme Court wrote the following quote, "We recognize the Florida House of Representatives versus Crist contained language suggesting the writ could be used to prohibit future conduct. However, the history of quo warranto as well as our precedent belie any suggestion to this effect. In Crist, we explained that petitions for the writ historically have been filed after a public official has acted, and the disputed act had already occurred. In that case, the Florida House of Representatives challenged the execution by Governor Charles Crist of a compact with the Seminole Indian tribe of Florida." So what does this footnote to a 2017 decision suggest? And if you're citing to footnotes, man, you better say things like suggest, right? What is the Latin phrase we use as lawyers to describe the language of an opinion that wasn't intended to have binding effect or that doesn't have binding effect? Yes. Dicta, D-I-C-T-A, that's right. If you're quoting from a footnote, you better be wary of dicta. If it wasn't important enough to put in the body of the decision, was it really intended to have binding effect, right? So is that the answer? Is that not the answer? Time will tell. But as a good lawyer, you have to know that issue, be aware of that issue, and when the time comes and a party that you represent needs it, to act upon that issue. Note 8, Article 4, Section 1 of Florida's Constitution states that, quote, the supreme executive power shall be vested in a governor who shall transact all necessary business with the officers of government, end quote. Florida House of Representatives versus Christ holds that this, quote, necessary business, quote, clause of Florida's Constitution does not authorize Florida's governor to execute compacts contrary to the express public policy of the state or to create exceptions to state law. Does this make the authority of Florida's governor different than the authority of the United States president? Consider, for example, the proposed Development, Relief, and Education for Alien Minors Act, or DREAM, DREAM Act, that failed to pass in the U.S. Congress from 2009 through 2012. Had it passed in any one of those years, then it would have prevented deportation of certain dreamers and made them eligible for work permits. After Congress, the U.S. Congress, did not pass that law, the U.S. president issued an executive branch memorandum on June 15th, 2012. It deferred action on deportation of dreamers and made them eligible for a certain type of work permit. In a way, the presidential action implemented a public policy that the national legislature decided not to implement. Does Florida's governor have a similar power to implement a public policy that Florida's legislature decides not to implement? Or would that be a violation of Florida's separation of powers? Based on Florida House of Representatives versus Christ that we've been studying for the past 45 minutes, what do you think? What do you think? Yes?
Well, with the Dreamers Act and the immigration in general, Congress has delegated a lot of the immigration powers to the president.
True.
So, but here in the Christ case, those powers were not delegated to the governor.
Very true.
And in the case, I think what the Supreme Court said was whether or not the governor could negotiate with the tribes was not whether that was necessary business. They didn't want to address that, but certainly when he did the necessary business and extended the laws, that was the usurpation power.
So you see in Florida House of Representatives versus Christ, if I'm hearing you right, you see a clear violation of separation of powers.
Well, the court did because what he did with the compact violated the separation of powers, but the court said that they were not going to address whether or not the governor could create a compact if it were within the confines of the Florida laws.
So they left that question undecided.
Exactly.
Which again would be a type of judicial restraint, would it not?
Right.
Yeah.
And so I guess to answer your question, I think that for the president, since he was acting under assumed delegated powers, and here the governor wasn't assumed governor or delegated powers. And the judges left, or the judiciary branch left necessary business open to interpretation.
Yeah.
The question for me.
I respect your opinion, especially since it's so well reasoned. I respect it. And we all respect it, but does anyone have a different opinion? All right, we not only respect it, but there seems to be quite a bit of concurrence here in the crowd. Maybe I can play devil's advocate. I don't know. Maybe I can try to reach a different conclusion. And again, without any disrespect to you and the multitude, I should say, that agree with you. But under Florida's Constitution, perhaps we could interpret Florida House of Representatives versus Christ And it's clear finding that the source of public policy is Florida's legislature. Perhaps we could interpret it as a greater restraint upon our chief executive, the governor, than we find under the chief executive, the president. Now, granted, there are a lot of unanswered questions when it comes to the powers of the U.S. president. The same is true when it comes to the powers of Florida's governor. But I would suggest that one way to interpret Florida House of Representatives versus Crist is to say that even though there's not a clear law on the books that textually prevents a particular action by Florida's governor, if we can see a clear public policy to the contrary of Florida's governor's action, and we do not see clear authority for the governor to take that action, then we bind the hands of Florida's governor under Florida's Constitution. And again, just as your conclusion was an opinion, what I've just stated is an opinion. Opinions are like noses. Everybody has one. The crowd appears to prefer your nose over mine, and I respect that.
I don't think you disagree.
Well, so you see some agreement in what we're saying.
Yeah, I don't see
Okay.
any disagreement. I just like, hypothetically, if the governor acted within the confines of the Florida statutes,
Okay.
he could have acted is how I read the case. Like,
Yeah, and I agree with you there too. So you're right. There's quite a bit of agreement with us. Yeah. All right. I'm always looking for those places where federal constitutional law and Florida's constitutional law might not be exactly the same. Because if I don't, then what was the point of taking this class, right? Okay, so maybe I found there, maybe I didn't. But it's up for debate. And I enjoyed debating it with you. Thank you. Cooperation among the branches. This is when the branches of government agree. Kind of like in the end, you and I agree. Yeah. So cooperation of branches. And I gave two conflicting cases. Is that the right definition of what these two cases were? Conflicting cases? I gave two cases that were weeks, at most months apart. They were both decided in the year 2018. But through historical happenstance, even though they were both decided in 2018 and both decided by the Supreme Court of the state of Florida, they were both decided by two different judicial panels. Now, you remember from our lecture last week, Supreme Court of Florida doesn't sit in a panel. All 7 justices decide each case. But when it comes to the first 2018 decision of DeLisle, do I pronounce it right? D-E-L-I-S-L-E? It's up there on the big board. DeLisle versus Crane Company, the 7 justices who made up the Supreme Court of Florida were not the same a few weeks or months later in the 2018 decision called En Re Amendment to Florida Evidence Code, right? So what happened here? What was going on? Well, with the first case, DeLisle, is that how you pronounce it? I hope I'm pronouncing it right. D-E-L-I-S-L-E. DeLisle, how'd you pronounce it? You like Delisle? You say tomato, I say tomato. Let's call the whole name. That's a reference to like a 40 song. I was not alive then, I swear. Okay, all right. So in this Crane Company decision, how's that? All right, in the Crane Company decision, the debate was, do we follow Fry or do we follow Daubert? And just as I probably went too far into the substantive law of gambling and gaming, I don't want to make the same mistake and go too far into Daubert versus Fry. Suffice it to say that these are two different alternatives, two different ways the judiciary can serve as the gatekeeper and decide whether or not certain scientific evidence is reliable enough to come into evidence in a court of law and be decided or be considered by the judge or jury in that case. So it's a rule of evidence, whether it's Fry or whether it's Daubert. In the one case, the legislature had dictated one, and the court deferred. In the other case, the court did not defer to the legislature. So what's the lesson? What is the takeaway? Who gets to decide the procedural rules of the judicial branch. Perhaps not surprisingly, many in the judicial branch were arguing that the judiciary should decide that, right? Notes and questions to consider. Note number 1. I am now on page 283. Note number 1. In the Crane Company case, Florida Supreme Court declines to replace the Frye rule with Daubert. A few months later, and with 3 retiring Supreme Court justices having been replaced with new justices, Florida Supreme Court replaces Frye with Daubert in its in re amendments decision. To what extent was the different outcome attributed or attributable to changed circumstances? And to what extent was it attributable to changed personnel? Cheap shot, don't you think? Yeah. I tell you, we've all got pet peeves. My pet peeve is the constitutional law class in the law school that just says, oh, it just depends who's on the bench. That's the outcome. And granted, maybe sometimes it just depends who's on the bench and that's the outcome. But what does that lesson teach the law student? What skill does that give to the law student? How does that empower the lawyer to argue a constitutional law case? Do I send law graduates up to a Supreme Court and have it argue, well, now that you're different people up here, you should give me a different outcome? That was my ode to Walt Disney. That was Goofy. Did you recognize him? That Disney character, Goofy? What's that? I've been goofy all year long? Sorry about that. But no, we need better logic than that, do we not? Note 2, noting that Florida's Constitution makes judicial rulemaking the sole province of Florida Supreme Court. Is it wrong if a change in judicial rules is the result of a change of personnel? Oh, okay, a little less cheap of a shot there, huh? All right. So where am I going with this? Well, the different branches of government have the constitutional right within the confines of the Constitution to set their own rules. When it comes to the executive branch in Florida's Constitution, we know how you get to be governor. We know how you get to be a cabinet member. And we know that certain meetings have to contain certain cabinet members. You remember that study from that lecture. But within those confines, the governor gets to choose her or his own secretary, gets to choose her or his own executive staff, and gets to decide her or his own priorities. Likewise, the legislative branch. The Constitution spells out lawmaking and its limits. We've studied that in great detail. Within those confines, the legislature gets to decide how to convene and do the work that it is delegated within Florida's Constitution. And here we see from DeLisle versus Crane Company and in re amendments that likewise the judicial branch has its province. What is that? It's a question of substantive law versus procedural. Substantive law spells out the rights, duties, responsibilities. That is not what the judicial branch is intended to create. Instead, the procedure by which to adjudicate those issues of rights, duties, and responsibility that are properly before the judicial branch in a proper case or controversy. How are they decided? They're decided by rules of procedure that are created by the judicial branch under Florida state government. So that's the takeaway. And that's how we end the first of our 3 chapters and the first of our 2 hours of lecture we've got together today. I finished 1 chapter in 1 hour. When we come back, I got to finish 2 chapters in 1 hour. And I'm putting the pressure on myself because I'm very proud of myself. I never fell behind the syllabus this semester. I started class number 2, exactly where class number 2 was supposed to start, had nothing left over. Likewise, Class number 3 started at the topic it was supposed to start. I didn't fall behind. Class number 4 started at the right place. I didn't fall behind. Class number 5 started in the right place. Didn't fall behind. Class number 6 started in the right place. Didn't fall behind. Class number 7. I want to keep the pace, man. So if you're rooting for me, then help me in this way. Let's yet again keep our break short. How's 5 minutes sound? Can we do it in just 5 minutes? All right. I'll see you in 5 minutes. And we'll cover 2 chapters in 1 hour, just as the syllabus says we would. Oh, I didn't cover that at all. I was going to make a video. Yeah, and I wasn't going to cover them in class. Well, it's a tough decision to make, but things that are housekeeping, I try not to take up lecture time with. And I know maybe going over the answers isn't exactly housekeeping. But, on a case-by-case basis, if you got that question right, you don't really need the explanation. If I put it on a video, the people can fast forward to what they want to see. So that's why I'm going to put it on a video. Okay? I graded anonymously, so I don't know which ones you missed, but I bet you it was next to none.
These are Jack and Meg White, also known as the White Stripes. They're a band from Detroit. They make rock and roll without a bass guitarist. This is Steve McDonald of the veteran band Red Cross. Steve thought that White Stripes could use a bass player, so he appointed himself. He took the White Stripes album, White Blood Cells, and re-recorded it, laying a bass track down on every song. Then he released the results as MP3s on Red Cross's website. He even made up a new album cover and title, Red Blood Cells. McDonald began putting these copyrighted songs online without permission from the White Stripes or their record label. During the project, he bumped into Jack White, who gave him spoken assent to continue. It can be that easy when you skip the intermediaries. Collaboration across space and time. Creative co-authorship with people you've never met. Standing on the shoulders of your peers. It's what the internet is all about. It can be that easy when you skip the intermediaries. But couldn't it be easier still? Not many of us are liable just to bump into Jack White and get the green light. And he's not going to let just anyone play the bass over his songs in any case. But what about other artists who might want you or me to play along? Shouldn't we be able to, if they don't mind? Enter one of the internet's most famous citizens. A face familiar the world over, a public identity rivaled only by a handful of corporate giants and global superstars, the Big Copyright C. Everyone knows what Big C stands for. Big C means all rights reserved. Big C means ask permission. Big C protects copyright owners and notifies the rest of us of their ownership. The time was when you had to put Big C on anything you wanted to copyright, or else it entered the public domain. The commons of information where nothing is owned and all is permitted. You had to put the world on notice to warn them. That was Big C's job. And it was a useful one. What changed? The law. By the late 1980s, U.S. law had changed so that works become copyrighted automatically the moment they're made. The moment you hit save on that research paper, the second shutter snaps closed, the instant you lift your pen from that cocktail napkin doodle, your creation is copyrighted, whether Big C makes a cameo or not. So suddenly, there's no quick way of knowing whether something's owned or not. The new rules may be clear about how you get to own work. You don't have to do anything. But they say nothing at all about how you should go about announcing that you want to allow certain uses of your work. So what? Well, if you're a digital filmmaker whose every frame must be cleared by an army of lawyers before making a cut, or if you're in a band whose label won't let you put a song on a file-sharing network, or if you're a professor trying to put together online course materials, or if you're a DJ chasing down permission to use every snippet of song in your sonic collage, if you're one of these people, then you know, so what? We interrupt this brainstorm, call the lawyers. You drop what you're doing and call all the lawyers. You ask for permission. Even to use a word the author doesn't mind if you use it, because you have no idea what the author's intent is. You ask for permission, you can share some of your rights. Or you venture forward unsure what your risks and rights are exactly. Or, in a haze of legal doubt, you do nothing. Bottom line, Big C is out of a job. The middlemen are not.
Welcome back, everybody. Thanks for keeping that one short. I do appreciate it. Hope it wasn't too short. As always, feel free to get up, leave, and come back as you need for whatever purposes you need. But thank you for keeping the official break to just 5. Actually, I guess it was 7 minutes, but whatever it was short, and I appreciate it. So now welcome back, and on our next chapter, we have our next topic. Our next topic is sovereign immunity. Sovereign immunity. What is sovereign immunity? Perhaps we should start with a definition. Sovereign immunity, or crown immunity, is a legal doctrine by which the sovereign or state cannot commit a legal wrong, and the sovereign or state is immune from civil lawsuits and immune from criminal prosecution. What? Are we saying that someone or something or some entity or some or all of those are above the law? Sovereign immunity, is this a concept that says that there is an entity or a person or a group that is above the law? Well, let's explore that concept and that question a little better. Let's get an answer to that question. To start the answer to that question, let's turn to the text of our state's constitution. In the state of Florida, it is Article 10, Section 13 of the Constitution of the state of Florida that directly addresses the sovereign immunity of the state of Florida. Take a note of this language. It's on the big board. It says, provision may be made by general law for bringing suit against the state as to all liabilities now existing or hereinafter originating. Putting the multisyllabic presentation aside, I ask you this: what's the perspective of the author of that sentence? The perspective of that author is that the state of Florida is immune, but that through general law can be made liable. Do you agree with me? Don't you see that's the perspective of the author of this sentence? Look at that. Not that the state is liable, but that provision may be made. Not that it has to be made or that the rights of the citizens demand that the state be held accountable. No, that's not how this author of this sentence is writing. The perspective here of the author of this sentence is that you can make the state liable, but it isn't already. From the perspective of the author of this sentence, the state is, to a certain extent, above the law. But is that true? Is that the outcome? Is that the result? And to help find out, let's start with this preliminary question. Why, in this day and age, would laws making the government above the law persist? Why? In this enlightened age of ours, and we're not enlightened enough, but certainly more enlightened than the past, why would we continue to tolerate the concept that this state of Florida or any state in our union or any other sovereign would be above the law? Is there any good reason for that? When we look at our text, we see with hesitancy some explanation from the Federalist Papers. You see, I've quoted many sentences from Federalist number 81, page 487, in my textbook that I wrote for you on page 286. Federalist Papers explain, quote, "It is inherent in the nature of sovereignty not to be amenable to the suit of an individual without its consent." Pausing the quote right there for a moment. The author of this Federalist paper comes to this topic from the same perspective as the author of that sentence quoted from Article 10, Section 13 on the big board. Comes from the perspective of acknowledgement of sovereign immunity, right? So from both perspectives, whether it was the 1968 Constitution that I just quoted to you there from the state of Florida, or whether it's the 1789 or earlier Federalist Papers number 81 that I just quoted to you, it appears that there were generations of authors that assumed that sovereign immunity exists. To continue the quote from the Federalist Papers number 81, quote, "This is the general sense and the general practice of mankind, and the exemption as one of the attributes of sovereignty is now enjoyed by the government of every state in the Union. Unless, therefore, there is a surrender of this immunity in the plan of the convention, it will remain with the states, and the danger intimated must be merely ideal. The circumstances which are necessary to produce an alienation of state sovereignty flows from the obligations of good faith. The contracts between a nation and individuals are only binding on the conscience of the sovereign and have no pretensions to a compulsive force. They confer no right of action independent of the sovereign will. To what purpose would it be to authorize suits against the states for the debts they owe? How could recoveries be enforced? It is evident it could not be done without waging war against the contracting state and to ascribe to the federal courts by mere implication, and in destruction of a pre-existing right of the state governments, a power which would involve such a consequence would be altogether forced and unwarrantable," end quote. So what's the Federalist Papers warning us about sovereign immunity? One, that it's real, that it exists. Two, that because it exists, we have to rely upon the sovereign to either waive it or lessen it or abrogate it. And third, if the sovereign isn't wise enough to do that, we can face something worse than tyranny. We could face outright war, at least from the perspective that you just heard in the quote of the Federalist number 81. So why would this persist in this day and age? Why don't we just erase it? Well, I suggest that there might be good purpose to it. Let's see if I can dream up a hypothetical that might, emphasis on might warrant the persistence of the existence of sovereign immunity. Imagine, if you will, pick any actor of the state, someone who's a state employee, driving a motor vehicle, drives it negligently, runs over the most sympathetic of victims that you could imagine. Imagine a jury hearing this case is so offended, so outraged by the state's behavior, and so sympathetic to the tortfeasor's victim that the jury literally and truly awards $4.8 billion. You heard me right, boom, $1 billion. Okay, so there's your hypothetical. Got a very worthy and deserving and sympathetic victim of the state's tort with a $4.8 billion judgment. Where's that $4.8 billion coming from? Anybody got a mirror they can look in? You're raising your hand. It's coming from you, sir.
Yeah, I'll pay it.
You're going to pay it. All right. We're all going to pay it. We're all going to pay it. Every Floridian's going to pay it. What does that mean for the money we would have spent on Florida's roads and bridges? What does that mean for the money we would have spent on Florida's schools and education? What does that mean for the money we would have spent on Florida's safety net and government programs? What does that mean for the money we would have spent on everything else that the state is obliged to pay for? It could do more than bankrupt a state. It could burden a state for generations. You and your children and your children's children and their children, all of whom are Floridians, still paying off that $4.8 billion judgment. That doesn't change the fact that the victim was worthy of that money. It doesn't change the fact that that, in this hypothetical, was an accurate calculation of economic damages. But with all that said, without sovereign immunity, what becomes of the state's ability to provide the necessary goods and services that the citizens require for their well-being? That's the best hypothetical I can come up with to warrant the existence of sovereign immunity. Maybe you've got a better one. Font of law versus font of justice. One theory of sovereign immunity is that since the sovereign is the source of law, it need not follow those laws. One theory of sovereign immunity is that since the sovereign is in charge of administering justice, it need not administer justice against itself. These are two competing theories as to where sovereign immunity came from. Pick your theory, but one theory you cannot pick is that sovereign immunity does not exist. You can't pick that theory because it's just not true. It clearly has existed, and it clearly continues to exist. Notes and questions to consider. We are on page 289. Note 1, why in the modern era would such a concept exist? And then I gave that jury example. Oh, this time the jury just did $20 billion. Didn't I do like 10 billion? I tell you, every time I give this example, the billions are going up. But maybe you can see my point. Maybe you can see that one thing sovereign immunity does is protect government services. I ask here, when I give the hypothetical again, I ask in note 1, where would the state of Florida obtain that money? What Florida bills and obligations would be unpaid in order to satisfy that judgment? What government services would Florida stop providing in order to satisfy that judgment? Does this scenario illustrate how it might be in the best interest of Floridians for the state of Florida to have sovereign immunity? Does it? That's a matter of opinion. Opinions are like noses. Everybody has one. Ever heard that phrase before? Note 2. Certainly it is practical for the state of Florida to have sovereign immunity. But in your opinion, is it equitable? Imagine a plaintiff who is injured catastrophically by the negligence of the state of Florida and for whom all experts agree has suffered economic damages in the form of wage loss and future medical care in the amount of $12 million. Imagine that Florida's sovereign immunity caps the damage award at $300,000. Does sovereign immunity create a fair result for that plaintiff? No. Anybody want to answer that with a yes? That one's a no. Okay. No, 3. In the scenario from the last question, has sovereign immunity achieved its goal of protecting the public treasury in such an instance? Oh, interesting. McGinley, that hypothetical you were given about states going broke, I guess you were saying you're trying to protect the state treasury. Let's read on here. Has sovereign immunity achieved its goal of protecting the public treasury in such an instance? After that plaintiff who suffered wage loss and future medical care in the amount of $12 million, after that plaintiff has exhausted the $300,000 award, will the plaintiff turn to public assistance to finance the balance of the plaintiff's future financial needs? Will this adversely affect the public treasury? Well, it seems almost certain. Churches and charities and public assistance from the government will be necessary to help that hypothetical plaintiff, right? So to the extent that that hypothetical plaintiff is helped by the public treasury, then no, you haven't protected the public treasury, have you? Something to think about. But as we think about sovereign immunity, we are lawyers. We have to deal with sovereign immunity. We have to know when sovereign immunity applies, how it applies, and whether or not we can get around it. That question is who's immune from what and from whom? Who's immune from what and from whom? I suggest there's 3 separate issues to look at here. The first of the 3 separate issues is whether the state of Florida and or its counties and or its cities and municipalities are immune from a claim that arises under state law. Remember, under that font of law theory of the source of sovereign immunity, it's the fact that the sovereign made the law that yielded its sovereign immunity. Now, there are state laws, correct? And there are federal laws. That's not news to you. But in point 1, I'm looking at the state laws, the laws that arise from a state of Florida and the liabilities that arise from the state of Florida's statutes. That's what I'm talking about in point 1. And I'm talking about whether the state is immune. So maybe I don't draw much because I don't draw well, but maybe some drawing, some artwork is in order. Who knows? All right. Try not to block the big board. Am I blocking? Can you see the big board? You can't see. I did block the big board. Okay. Can still see the. Can see the. Did that help at all? Still can't see the big board. Okay. How about now? Can you see me? Just kidding. Okay. All right. Maybe we don't want to draw. I don't draw very well. All right. What I would draw if I was drawing. Okay. On this side, you've got state law. On this side, you've got federal law. Either one can create an obligation. But in the first of these 3 separate issues, I'm talking about the obligation that arises under state law. That's the what. The who or whom is the state or its counties or its municipalities. That's the first of 3 separate issues. The second of 3 separate issues has to do not with the state law claim, but the federal law claim. When it comes to federal law claim, I'm going to break down the whom or the who. First, I'm going to ask, is the state of Florida immune from the federal claim? And next, I'm going to ask, are counties, municipalities, or entities created by counties and municipalities immune from the federal claim? So you see, when it comes to the state law claim, I'm bunching the state and the counties and the municipalities all together because they're all going to have the same answer. Spoiler alert. But when it comes to the federal law claims, I'm going to look first at the state of Florida and then look at the counties, municipalities, and the entities they create. Got that even without the drawing? All right, so let me take it one at a time. Let me look at the first of the three issues. What I'm looking at here is whether there's immunity from a state law claim. And I'm looking at whether the state of Florida or its county or its municipalities are immune from that state law claim. This is the general rule that answers that question. Florida state immunity is total, but lesser sovereigns are not. What I'm saying is that the state of Florida is immune, but counties can use the state of Florida's immunity when the task the county was performing was the arm of the state. Sometimes the state has an obligation to provide certain benefits or services to its citizens. The state can do that directly. Another option is for the state to delegate the doing of that obligation to a county. It's still the state's obligation, but the county has received instructions and funding from the state. When that happens, the county is exercising the arm of the state, says the case law. And because it is exercising the arm of the state, the county gets the state's sovereign immunity. Municipalities are not immune from tort liability when the municipalities are performing the municipality's proprietary functions. What are the proprietary functions? The case law tells us that proprietary functions are those functions of a proprietor, by which we mean of an owner. Just like you and I can own private property, a municipality can own private property. For example, you might own a motor vehicle. Likewise, a municipality might own a motor vehicle. Just like you and I have to refrain from operating that dangerous instrumentality of a motor vehicle in a negligent way that hurts others. Likewise, a municipality as a proprietor of a motor vehicle must refrain from operating it in a negligent way that hurts others. If instead that motor vehicle owned by the proprietor, the municipality, hurts another because it was operated negligently, then the municipality is not immune from tort liability. This is the common law rule of immunity from state law claims that is held by the state of Florida, its counties, and its municipalities. But this common law immunity is affected by statute, such as Section 768.28. As you know, Chapter 768 of the Florida statutes speaks of tort law. 768.28 speaks of how sovereign immunity is abrogated and inapplicable to a certain extent when you bring a tort claim against the state of Florida or its county or its municipality. So in addition to the slide you see here, which is the common law, depending on what you're doing, you're going to look for a statute, fellow lawyer, to see if the legislature of the state of Florida has expanded or abrogated this common law sovereign immunity. I won't go over every statute in this lecture, just like I didn't go over every statute in the book. That could be a 1 credit hour class by itself. The lesson is, if you're bringing a state law claim against the state of Florida or a county or its municipality, you know the common law rule and you look for an applicable statute in the Florida statutes that might affect that common law rule. For example, say you're bringing a tort claim. You're going to look at our Chapter 768, our tort laws, and you're going to note Chapter 768.28. It's a long statute. I've only got a few quoted words from it up here on the big board. Let's look at those words. 768.28 of the Florida statutes tells us, quote, the state and its agencies and subdivisions shall be liable for tort claims. Because this statute says they're liable, they become liable. But this statute limits your recovery and also creates pre-suit requirements. So you've got to exhaust the pre-suit requirements, and you can't recover more than the statute allows you to recover. To continue the quote, liability shall not include punitive damages or prejudgment interests. But my client's entitled to those. Great. You're just not going to get them in a judgment against the state in tort, in state court law suits here in Florida. Neither the state nor its agencies or subdivisions shall be liable to pay a claim or judgment by any one person which exceeds the sum of $200,000, or when totaled with all of the claims or judgments exceeds the sum of $300,000. That's a quote from section 768.28. Statutes are changed. Numbers are updated as time goes by. When you are practicing, you open up 768.28, the current version, and you check the current amount. You do that throughout your career. You be thoroughgoing about that. That portion of the judgment that exceeds this amount may be paid in part or in whole only by further act of the legislature. McGinley, what's the lesson? What's the takeaway? Bring this down to earth for me. Give me an example so I can grab this. Okay. I heard you. I'll do that. There you are, my fellow lawyer, with the case of a lifetime. You were brilliant. The jury hung on your every word, like all of you do when I speak. You got to laugh at that. Come on. The jury hung on your every word. And they came back, the verdict. You're working on a contingency. You are particularly interested in this verdict because you're going to get 40% plus your costs. They fined for your client, the plaintiff, against the state of Florida in this tort action in the amount of $10 million. You do your best to try to stay cool. You turn to your paralegal. You say, I heard 10 million. Did you hear 10 million? Your paralegal says, 10 million! And you feel the same way inside. Judge says, jury, thank you for your service. It's 7:30 at night. I'll see counsel back in the morning. Until then, the jury's dismissed and the gavel goes down. And so do you. You go down to local Fiddler's Green and you enjoy your Miller High Life. The champagne appears because you've earned it. You call your mama and your dad. You call every friend that you know. You start posting on Twitter and Facebook. You just got 40% of $10 million plus tax and costs. Don't forget that. And you come back in the morning, just as the judge said, and you've got the judgment for the judge to sign. It's written so beautifully. It says, $10 million for which sum let execution issue. And you're imagining in your head the sheriff confiscate all the state stuff and selling it at auction because they're letting execution issue, right? So you hand it to the judge, and the judge takes it, and she says, thank you. She grabs her pen, and she's about to sign. Oh, just one thing to change. She changes something, she signs it. She changes something. She changes something. You get the paper back. What did she change? What did she cross out? She crossed out $10 million. The judge crossed out $10 million. What did the judge write instead? Judge wrote $300,000. Why? That's why. 768.28. 768.28 talks about sovereign immunity. It says what? Can't exceed $300,000. It's right there. You might have had one Miller High Life too many. You got a bill to pay, and it's not going to be out of 40% of 10 million. It's going to be out of 40%, or actually, if you read 768.28, they're going to limit your percentage too. But a percentage of 300,000. Well, how do I get the rest of the money, McGinley? Oh, that's easy. You're owed what? $9,700,000. All you got to do is contact your local House of Representative member of the Florida House of Representatives or Florida Senate, right? And they got to pass a law that says that you get the rest, and it's got to be passed by the majority of both houses, the House and the Senate. That's it. How do I do that? I don't know. I'm a lawyer. I'm not a lobbyist. But that's what the last sentence means. That portion of the judgment that exceeds these amounts may be paid in part or in whole only by further act of the legislature. So that's the answer to the question about sovereign immunity. Sovereign immunity of municipalities is construed strictly, whereas the immunity of the state must be construed more broadly. Under the common law, the state's immunity was total, but municipalities never enjoyed total immunity. Before Section 768.28, in proprietary functions, a municipality had the same tort liability as a private corporation. What's the mystery on my slide here? Essentially, the state and its agencies on the one hand, and municipalities on the other, arrived at 768.28 from opposite directions. The state from a status of near total immunity, and municipalities from a status of near non-existent immunity. So 768 does two things. It makes the state more liable than it was under the common law rule that I read to you, and it makes the municipalities more protected and less liable than they were under the common law rule that I read to you. Yeah, that's interesting, right? Yeah. What about a contract? That's why I love the case of Pan Am versus Department of Corrections. You read it. You know the true facts. So you know that I'm taking a little bit of liberty with those facts when I present them in this not wholly accurate way that does a lot better job of keeping you awake. So Pan Am had a contract with the Department of Corrections. The Department of Corrections owed $800,000. Pan Am said, we would like our $800,000. Department of Corrections said, yeah, I bet you would. So finally, Pan Am went to court and sued for its $800,000 or whatever amount it was. Department of Corrections said, yeah, we do have a contract with Pan Am. It does say we owe $800,000. I bet they would like that. I bet they would. And sits down. The judge scratches his head and says, oh, well, all right. I don't know what kind of argument that was. What kind of argument was that, counsel? This is counsel for Department of Corrections. Stands up and says, well, it's a sovereign immunity argument, Your Honor. We have sovereign immunity. We didn't waive it. There's no statute where we waived it. Constitution didn't waive it. Yeah, we breached the contract. I would feel bad too if I was Pan Am. But we're not paying. Thank you again, Your Honor. And then the judge rules, and you know how the judge rules, right? Well, Supreme Court of Florida gets this on appeal. Supreme Court of Florida says, Department of Corrections, forget about it. Pay up. How do they get to this conclusion? Was this a ruling in equity? No. The Supreme Court of Florida decided that under the plain language of Florida's Constitution, if the state of Florida knowingly obliges itself freely to the terms of a contract and knowingly breaches that contract, then it has waived sovereign immunity. Now, where's that sentence in the Constitution of the state of Florida? Maybe you can't find it. I know I can't because it's not there. What they're saying is that the plain language of the Constitution of the state of Florida cannot be read any other way. The Supreme Court of Florida in this 1984 decision of Pan Am versus Department of Corrections says that's its source of authority for this outcome. So when it comes to sovereign immunity for breach of contract, essentially there is none. Is that because the state waived it? No. It's because of the decision in Pan Am versus Department of Corrections. Why is that binding law? Well, two reasons, and you already know them. First, Supreme Court of Florida, there is no other state court that you can appeal to. You know that. What about federal court? You also know that when the state of Florida is interpreting only the plain language of the Constitution of the state of Florida, that federal law recognizes Florida's highest court as the final arbiter of what the plain language of our Constitution means, so long as that interpretation has an adequate and independent state law basis. That's the ruling of cases such as Michigan versus Long from the Supreme Court of the United States. Pan Am versus Department of Corrections, maybe you would have read the plain text of Florida's Constitution differently, but you're not in charge of that. Under federal law, the Supreme Court of Florida is in charge of that. That's how they read it, and there's nowhere to appeal from. So that's why there is no sovereign immunity to a breach of contract claim for the state of Florida or its counties or its municipalities. It's not because it was in the Constitution, it's because it was in Pan Am versus Department of Corrections. If you're a big fan of judicial restraint, you are in tears over Pan Am versus Department of Corrections. But it's a 1984 decision that has, for better or for worse, stood the test of time and remains good law today. Notes and questions to consider about Pan Am versus. Where, on what page? That is page 299. 1, how can the outcome of Pan Am versus Department of Corrections be reconciled with these prior rulings from Florida Supreme Court? Quote, any waiver of sovereign immunity must be clear and unequivocal. That was Arnold versus Schrumpert, Florida Supreme Court, 1968. Quote, the only way that the state can give its consent to be made a party defendant to a suit is by legislative act. Quote, that was Suits versus Hillsborough County, a 1941 decision of Florida Supreme Court. How can they be reconciled? They can't. No question to consider number 2. Pan Am versus Department of Corrections holds that where, quote, where the state has entered into a contract fairly authorized by the powers granted by general law, the defense of sovereign immunity will not protect the state from action arising from the state's breach of contract. Quote, what Florida statute says so? Answer, none. Prior to the decision of Pan Am versus Department of Corrections, what Florida case law precedent said so? Answer, none. Okay, we're doing good here, right? Note 3. Do you sense any sarcasm in my questions? Note 3. The holding of Pan Am versus Department of Corrections explicitly overrules all contrary prior decisions, including one decided back in 1895. When the Department of Corrections breached the contract in the 1980s, did not they have the right to rely on case law precedent dating back more than 85 years? Answer, apparently not. Okay. Note 4. After Florida Supreme Court decided Pan Am Department of Corrections, none of the parties sought review from the United States Supreme Court. Under the adequate and independent doctrine as interpreted by Michigan versus Long, would the U.S. Supreme Court have jurisdiction to review Pan Am versus Department of Corrections? They didn't try, so we don't know for sure. My learned opinion, if you consider my opinions learned, my opinion is that there would not have been jurisdiction. So, where the state has entered into a contract fairly authorized by the powers granted by general law, the defense of sovereign immunity will not protect the state from action arising from the state's breach of contract. That is good law. That is the holding of this case. And that summarizes whether the state of Florida or its counties or its municipalities are immune from state law claims. But we want to look at federal law claims. And before we look at all the state of Florida and the counties or the municipalities, let's just look at one of those. Let's just look at the state of Florida. Let's ask whether the state of Florida is immune from a federal claim. We know that the Constitution of the United States in the 11th Amendment says the following: the judicial power of the United States shall not be construed to extend to any suit against one of the United States by citizens of another state or by citizens or subjects of any foreign state. So what's that mean? That's sovereign immunity, right? We can't use the federal courts to extend a suit against one of the by citizens of another state or by citizens or subjects of any foreign state. That's sovereign immunity right there. Because Florida has sovereign immunity, the U.S. Congress cannot use its powers under Article 1 of the federal Constitution to subject Florida or any other state to suit in federal court without the state's consent. Therein lies the rub, ladies and gentlemen. Without the state's consent. Must that consent be expressed? Yes, or it can be implied. One of the ways it's implied is by the state joining the Union. Because when you join the Union, you signed on to the Constitution, which contained things like the Supremacy Clause. Or as this slide explains it, exceptions arise when the text of the federal Constitution allows the U.S. Congress to abrogate state sovereign immunity, and then Congress passes a law that properly utilizes that power. For example, it is constitutional for the U.S. Congress to pass bankruptcy laws. Therefore, sovereign immunity will not be a defense to bankruptcy. It is constitutional for the federal government to pass civil rights laws. Thank God. Therefore, states will not be immune to civil rights claims. Can the state say, hey, we're the state of Florida, so we're going to discriminate against this group, or we're going to discriminate against that group, or we're going to treat worse this group, or we're going to run roughshod over the rights of that group? No, because the civil rights laws say that they cannot, and there is no sovereign immunity defense. So that brings us to the other part of the federal claims. We just discussed whether the state of Florida is immune from a federal claim. The answer was it can be sued if it gives consent, but that consent can be implied. Now we asked a question about federal claims, but not about the state of Florida. Instead, we're looking at Florida's counties, Florida's municipalities, and the entities that Florida's counties or municipalities might create. Are they immune from federal claims? The answer is that municipal defenses, including an assertion of sovereign immunity to a federal right of action, are, of course, controlled by federal law. Federal law is going to tell us. By including municipalities within the class of persons subject to liability for violation of the federal Constitution and laws, Congress, that's the supreme sovereign on matters of federal law, abolished whatever vestiges of the state's sovereign immunity the municipality possessed. For example, under the Federal Civil Rights Act, persons can be held liable. And the act defines the term persons and says that persons includes counties, cities, and municipalities. No, they're not living, breathing flesh like you and I are, but they're included within the federal definition in the Federal Civil Rights Act of person. And therefore, that inclusion in federal law abolished whatever vestige of sovereign immunity the municipalities possessed. A state's municipal corporations and similar governmental entities are persons under 42 U.S.C. Section 1983. And thus, Florida's cities and municipalities lack sovereign immunity from federal law claims that arise under that act. Now, a county can take on the state's sovereign immunity when the county can prove it is acting as an arm of the state. We mentioned that earlier, but what's the test for that? How do we know whether the county is acting as the arm of the state? It's allegedly a three-pronged test. I say allegedly because the third prong, if you pass that, you've passed the test. So if you pass the third prong, you've passed the three-prong test. McGinley, shouldn't I have to pass like the majority, like 2 out of 3, or shouldn't I have to pass all 3? Nope. As long as you pass the third prong, you've passed the three-prong test. McGinley, why is it called the three-prong test? Man, stop blaming me for this stuff. This is what the case law says. It's a three-prong test, and you just got to pass the third prong. First prong is how Florida state law defines the entity. Second prong is what degree of control the state of Florida maintains over the entity. And the third prong, I'll slow down because we actually got some meaningful prong here now, right? This is some good prong. Everybody want a good prong? Here's a good prong. From where the entity derives its funds and who is responsible for satisfying judgments against the entity. If the answer is the county got its funds from the state and the state is responsible for satisfying the judgments of the county, then my friends, you've just passed the allegedly three-pronged test. That brings us to our last chapter, which thankfully is our shortest chapter in the book, is it not? I think it is. This is our delegation chapter. Gosh, it's so short I flipped over. Okay, it is pages 305 to 310, and I've got 12 minutes left to cover. Think I can do it? Yep. I think so too. You're rooting for me. I appreciate that. All right. Delegation of legislative powers. Florida's executive, legislative, and judicial branches may delegate their power. That's allowed. What can't they do? They can't abdicate their power. So when we look at what one branch has done to allow another branch to act, we ask this question: is it a valid delegation? We answer that question by determining whether it is an abdication. Have they abdicated their authority? Any delegation of authority requires an intelligible principle to be laid down for the guidance of an administrative official in the performance of his or her duties. How do we know if it's an abdication? How do we know whether they abdicated? We look to see if, in giving that task to the other branch, whether or not the branch gave an intelligible principle for the guidance of the administrative person in performing the delegated task. So in other words, what if we give pure discretion? It's purely up to you. That would be a clear abdication. What if we give a laundry list of things that have to be true and have to be inquired upon, and based upon the outcome of the laundry list, a certain outcome might be this or a certain outcome might be that? That's a valid delegation. Do you see the difference? Do you see the difference? If not, you can look at Wiley versus Scott. This is a 2011 decision of the Supreme Court of Florida that you find there on page 305 to 311. It talks about the governor being quite concerned about rulemaking costing ordinary citizens money. Rule after rule after rule was incurring cost after cost after cost for Floridians and their companies and their families and their churches and their organizations. So the governor signed Executive Order number 11-01, suspending rulemaking and establishing the Office of Fiscal Accountability and Regulatory Reform, which they called OFAR, O-F-A-R-R. And basically, before you made a rule, you had to go through OFAR, so OFAR could do the math and find out what kind of burden the rule was creating. And then OFAR would let you either make the rule or not. Was this a constitutional delegation, or was it an unconstitutional abrogation? Quote, "We distinguish between the governor's constitutional authority with respect to the provisions of the executive orders pertaining to review and oversight and the legislature's lawmaking authority. The legislature retains the sole right to delegate rulemaking authority to agencies. And all provisions in both executive orders that operate to suspend rulemaking contrary to the Florida statute called the Administrative Procedures Act constitute an encroachment upon a legislative function." So this was unconstitutional. Specifically, why? The governor encroached upon the authority of the legislature. The governor wasn't delegating the governor's authority. A proper delegation is one where there's not an abdication. The court said that wasn't the issue here. The issue here was that Florida's legislature created Chapter 120 of the Administrative Procedures Act that tells agencies how to make rules. Then the governor slapped on top of that statutory scheme his executive order with additional requirements for rulemaking. That was not permissible because it constitutes an encroachment upon legislative function. So that tells us another restriction upon delegation, one of which to avoid encroachment. Next in our book, we talked about the case of Pierce versus State. This had to do with a restitution order. This had to do with a conflict between the judicial branch. The holding here was, quote, we affirm Mr. Pierce's judgment and sentence in criminal court, and we affirm the portion of the restitution order that establishes the restitution amount. We reverse the restitution order to the extent that it delegates authority to Mr. Pierce's probation officer to determine the restitution payment schedule. So what had happened was there was abdication. Instead of following the statutory scheme as to what payments are to be made when, the restitution order said, hey, probation officer, keep an eye on this guy, take account of his income, see how much he can pay, and vary the payments based on what you see. That was abdication. That was an invalid delegation. So that was impermissible. So when it comes to delegation of government powers and the rules of law that are unique to that under Florida's Constitution, there's not much there. I only had a few pages for you. And I hope I've done a fair work of summarizing them. But if you want a really great summary of not just this third of 3 chapters that we covered today, not just the second and third of 3 chapters today, but the first and the second and the third of all 3 chapters we covered today, what you want is to go to our class website, flaconstitution.com, and look at what your fellow students have drafted for you, what your lead counsel have drafted for you when it comes to the outline, because it is amazing. I would be honored if those students who participated in drafting it would please stand up, because I think y'all did a great job. You don't want to do that, that's okay. But you know who you are, and I think you deserve a round of applause. Thank you. Thank you very much. So we're still on schedule when it comes to our syllabus. Hopefully we'll stay that way. On Friday, you will see another update to our class website. You'll see the information you need if you wish to start on the graded essay. Then next week, you will see made available to you a video where I will be standing in front of the webcam explaining to you what the correct answers were to the questions on your midterm and why those were correct. I'll also go into why the wrong answers were incorrect, and hopefully that will help answer any concerns you had. But I doubt you had any concerns because your scores were amazing. I'm very proud of you, and I'm very thankful for you for working so hard this semester. I'm going to do my best to work just as hard as you do. Come to me with any questions or concerns. I am here to serve, and until I see you next week, may God continue to bless us all. Thank you. Thank you very much.